Before imposing sentence, the court notes for the record that it has considered the record itself, the relevant, material, and competent statements made here today, the pre-sentence investigation report, the victim impact statements, including the multiple letters, 32 of them submitted to the court, the defendant's lack of any prior record, and the nature of the offenses. The court must and has formulated its decision based upon the overriding principles and purposes of felony sentencing, namely, to protect the public from future criminal acts by the defendant or others, and to punish the defendant using the minimum sanctions that the court determines accomplish those purposes, without imposing an unnecessary burden on the state or local government resources, under Revised Code 29.11a. To achieve these purposes, the court has considered the need for incapacitation, deterrence, and rehabilitation. The court must and has also considered the seriousness and recidivism factors relevant to the offense and the offender, pursuant to Revised Code 29.12. The first factor is not helpful to the defendant, the second is. The court must and has determined that the sentence being imposed does not demean the seriousness of the offenses and the impact it had on the victim and next of kin and loved ones, and is consistent with other similar offenses committed by comparable offenders. Finally, of course, the sentence is not based upon any impermissible or irrelevant factors, including but not limited to race, sex, age, national or ethnic origin, sexual orientation, gender identity, or religion of the defendant. Do you understand all this, Ms. Paul? This case illustrates in terrible detail the toll that gun violence takes on American society today, and how reckless or even malicious handling of firearms has an effect not just upon the shooter, not just upon the person shot, but upon a broader community, family, friends, and loved ones. The risk assessment summary included in the pre-sentence investigation report shows the defendant at medium risk for reoffense as to all applicable factors: criminal attitudes, behavioral patterns, peers, family, social support, education, employment, finance, and substance abuse. The defense notes the defendant's lack of any prior record, her age, argues that no malice was shown here, and it was rather an act of recklessness. The state correctly notes that the defendant did flee, but did turn herself in 16 hours later, having altered her appearance, and did not volunteer to police where the weapon had gone. The state also notes that the shooting was at very close range, and in such a way that if the defendant did not know that the weapon was loaded, she must have intended to cause severe bodily harm, if not death, by pulling the trigger at that closer range. This case also illustrates that drinking and guns do not go well together. There is an agreed sentencing range of 15 to 25 years in this case. With all applicable factors considered, I believe that a 20-year sentence would be lawful, appropriate, and in the interest of justice. Accordingly, on a charge of involuntary manslaughter with a 3-year firearm specification, a felony 1, I will impose a 10-year prison term plus a 3-year firearm specification. As to count 5, discharge of a firearm in a prohibited premises, a felony 1, I will impose a 7-year prison term for a total of 20 years, 10 plus 3 plus 7. With Reagan Tokes, the sentence on the first count is potentially 10 to 15 years. As you'll remember, Ms. Paul, I advise you at the time of your plea, under the Reagan Tokes law, you have every incentive, you have every reason to obey the rules of the institution, not to get in any trouble, certainly not to hurt anyone. And if you do, you could end up serving an additional 5 years. You understand? The Reagan Tokes law does apply, and I will accept and implement the parties' agreement that the defendant will not be granted judicial release during the terms of this sentence. Anything further from the state at this time? Yes, thank you. You will be, as I advise you at the time of your plea, ma'am, be subject to post-release control from mandatory minimum of 2 years up to a maximum of 5 years. Anything further from the state? Or the defense?
No, thank you.
you have any questions for me, Ms. Paul? You're going to have a lot of time to think about what happened, to resolve to choose a better path forward. The day will come when you are released. I encourage you to consider very carefully what you've done, the terrible toll that your action took, and to pick that better path forward, to choose that better path, and resolve to be a law-abiding citizen, hurting no one from this day forward. Do you understand? The defendant is remanded to the custody of the Ohio Department of Rehabilitation and Corrections at the Ohio Reformatory for Women in Marysville, Sheriff to transport. We are adjourned. Many thanks to all who come in and address the court today.